Good morning, everybody. Welcome at our webinar regarding cross-border working in COVID-19 times, organized by KPMG Germany and Meijburg Co. I hope you can all hear me. My name is Martine Moore. I'm partner in the Amsterdam office, corporate tax specialist, and head of the German desk. I'm hosting this webinar on behalf of Meijburg. We have a panel of specialists today to talk you through the different tax and social security aspects of cross-border, which is of course a hot topic nowadays in the current setting of severe travel restrictions and general guidelines for working at home. In previous years, we also organized these types of events, but then it was a special Dutch-German tax day. Usually we organize this in the region of Venlo in the Netherlands in the month of June, where we could pick up some fresh asparagus on our way home. And now that we're all bound to our homes, we're very happy that you join us today on this issue and that we can reach out to you to share our experience on cross-border working. Let me introduce our speakers of today. We have Fanny Polsburskens, Senior Manager in our Global Mobility Practice, based in Eindhoven. And we have Sabrina Sangerman, our colleague in Global Mobility from the Düsseldorf office. International corporate tax expert from the Düsseldorf office. But first, the ground rules. Please make sure to mute your mic and your camera, so there's no disruption in the background. If you have any questions, please raise them in the chat function. We will not use the raise your hand button, which is also commonly used for raising questions because of the many participants. So if you have a question, please type it in the chat, and we have a team present to answer the questions in the chat during the presentation. Or if a more elaborate answer is needed, we will reach out to you after the webcast. And finally, we will issue a PE certificate if needed if you register with your full name previously. So we have little time and a lot of topics to cover, so let me jump to the agenda for today. First, we have some general questions, comments on cross-border workers in the Netherlands and in Germany. But then we'll dive into the mutual agreement concluded between Netherlands and Germany with specific measures taken for both countries. Then we'll discuss some further details on the social security aspects. Then we'll have some broader comments on international employees, so not just Dutch topics. Then we'll discuss some corporate tax considerations in times of COVID-19, and then some practical points of interest to close. So we have about 90 attendees now. Let's get started. Fanny, the floor is yours.
Yes, thank you, Martine. In the next 10 minutes, I will guide you to the main rules of taxation and social cross-border working between the Netherlands and Germany. I will also explain the issues that could appear due to the measures that both the German and Dutch government have taken due to COVID-19. And if we are talking about cross-border working, there are several ways how this can be formalized. Someone can live in one state and be locally employed with an employer in the other state and commuting every day to work in that state or sometimes work at home. Or someone can live in one state and work in one state and then be assigned by his employer to work in the other state. Also maybe commuting every day to that other state, or stay in that state during the week and then turning back in the weekends to the home state. Another option is that someone can live in one state having a commuter contract with his employer, where he partly works in his home state and partly works in the working state. What these situations all have in common, and what's typical for cross-border, is that the employee returns back to his home country at least once per week or 2 weeks. Therefore, he remains a tax resident of his home country. Well, yes. What about taxation of these cross-border workers? From both a German and Dutch local perspective, in principle, someone is taxable on his income in the state where he is a tax resident. However, in case that employee works in the other state also wants to tax that income from employment. So Article 14 of the tax treaty between Germany and the Netherlands then determines the right for taxation on employment income. The main rule of that article is that employment income is taxable in the country where the work is done. However, even though the work is done in that work state, the home country is still allowed to tax the employment income in case 3 conditions are met. The first condition days in the 12 months period in that work state. Second condition is that the remuneration is paid by or on behalf of an employer who is not a resident of the other work state. And third condition is that the remuneration is not borne by a permanent establishment of the employer in the other work state. So if all 3 conditions are met, the employment income is taxable in the home country. If not, so for example, if there's an employer in the host country, the employment income is taxable in the working state as far as the employee physically worked in that state. Well, those rules are typical for employees. The rules are different for a statutory director. His director's remuneration is taxable in the country where the entity is situated. Then Social Security. In Europe, we have the European regulation for Social Security that coordinates the Social Security systems within. Important to know is that based on this regulation, someone can only be insured in one member state at one time. And the main rule is that someone is socially insured in the state where he physically works. Well, besides that main rule, we have some special rules. For example, for an employee who normally works for an employer in the member state and who is assigned by that employer to work in another member state on that employer's behalf. He remains socially insured in that first member state, and this is often his home country. In principle, this is for a maximum of 2 years, but this can be extended to a period of 5 years. Another special rule is the multi-state worker, someone who works in 2 or more member states at the same time. This is what we see a lot with cross-border workers. Well, in case a multi-state worker works more than 25% of his time in his home country, he is who works less than 25% in his home country, he will be socially insured in the country where his employer is situated. But for all these special rules, both for assignment and multi-state worker, it's required to apply for an A1 certificate as a proof of the social security position of the employee. So far the general rules on taxation and social security for cross-border workers, which I went to fairly quickly, but I assume you are aware of these rules because more important is that we now want to know what the impact is during the COVID-19 period. Well, let's take an example. An employee who is living in the Netherlands and is physically working 100% in Germany for a German employer. In a normal situation, he would be fully taxable in Germany on his employment income, as he has a German employer who pays his salary. German employer, he is also socially insured in Germany. Depending on other personal income, he might be considered in Germany as unbeschränkt steuerpflichtig, which might lead to some tax advantages in Germany. Well, then COVID-19 came. And based on various measures of both the German and Dutch government, the employee was obliged to work at home as much as possible. Let's see what the impact of the fact that he now works 100% in the Netherlands in that period. Well, given the fact that he fully works in his home country and does not physically perform any services in Germany anymore, based on the tax treaty, the income would not be allocated to Germany anymore, but would be fully taxable in the Netherlands. From a social security perspective, he might work more than 25% of his time in his home country, the Netherlands, in a period of 12 months, and therefore he would be a worker being socially insured in the Netherlands. Well, what about that unbeschränkte Steuerpflicht in Germany? He does no longer have more than 90% of his income in Germany, so he might lose these advantages. Let's take the other way around. an employee who lives in Germany and normally works in the Netherlands for a Dutch employer. Same result, he's taxable in the Netherlands on his employment income and he is socially insured in the Netherlands. In his Dutch income tax return, he can opt to be treated as a qualifying Dutch taxpayer. So he is entitled to some personal benefits and he might even be able to deduct his mortgage interest on his German principal residence, which is of course a huge favor. But also he is not allowed to work in the Netherlands and remains at home during COVID-19. Or what we now see more and more in the last weeks is that someone is allowed to go to the office, but only for 2 days a week, and 3 days he needs to work at home. So what is the impact of that? His income would then partially be taxable in Germany instead of the Netherlands for the German working days he has. He might become socially insured in Germany because he works more than 25% in Germany. And he might lose his status in the Netherlands as qualifying Dutch taxpayer because he has no longer more than 90% of his income in the Netherlands. Therefore, he might lose the tax deduction on the mortgage interest and some other benefits. Well, as both examples show, COVID-19 could possibly affect the tax and social security position of employees working in a cross-border situation between the Netherlands and Germany. However, the Netherlands and Germany concluded a mutual agreement to avoid these situations. Sabrina Zangerman from KPMG Germany will now dive into this agreement and the details of it.
And their reduced travel activities. I will now introduce the solution that was put in place in early April between Germany and the Netherlands, already at the beginning of the COVID-19 pandemic. Most of you have probably already heard and read about the mutual agreement as a solution that was concluded between Germany and the Netherlands rapidly after the travel restrictions were put in place. The agreement should now mitigate tax disadvantages and bring clearness on the application of Article 14 of the Double Tax Treaty, as well as on the income tax situation of individuals that are generally working in one country whilst living in the other country and that are now forced to work from home. It also covers the treatment of employment income while being inactive at home during the current situation, as well as the treatment of social security benefits in a bilateral context. So, the mutual agreement was instantly applicable for the period March 11 until April 13 of this year. However, it is automatically extended until the end of the following month unless one contracting state, so either Germany or the Netherlands, has terminated the bilateral agreement. So far, the agreement has not been terminated by neither state. Therefore, it should be applicable at least until the end of July. Referring to the just given examples of funny, it became clear that based on Article 14 of the Income Tax Treaty between Germany and the Netherlands, employment income is generally taxed in the country where the work activities are performed if services are fulfilled, the so-called 183-day rule. To sum it up, without the mutual agreement, cross-border workers that are forced to work from home right now are suddenly no longer being taxed by the country where they work, but instead they are taxed in their state of residence, assuming that the home office work is performed in this state. This may cause negative effect if the tax rate in the country of residence is higher than in the working state, or if a tax relief depends on specific thresholds. Fanny just mentioned that an employee can be considered as a resident taxpayer in Germany in case 90% of the income is at least taxable in Germany. But now, as the number of German working days decreases during the COVID-19 pandemic, the German sourced income will most likely not exceed the threshold of 90% of the total income. Therefore, this would lead to a significant loss of tax benefits granted in Germany, as well as higher tax rates. The relief under the mutual agreement between the Netherlands and Germany therefore should ensure that cross-border workers will not suffer from any tax disadvantages by working from home. But let's have a closer look at the relief under the new mutual agreement between Germany and the Netherlands. Within the agreement, the following fiction is introduced for the duration the contract is applicable. Home working days can be considered to be spent in the state where the work would have usually been exercised without the COVID-19 measures. By looking at Article 14 of the Double Tax Treaty between Germany and the Netherlands, this means that the employment income relating to workdays spent at home during the COVID-19 situation can remain taxable in the usual working state, provided that, first, the employee sell his income from the employer, second, the employee stays at home during the COVID-19 measures and works at home, and that it concerns days that under normal circumstances would have been working days in the other state. So by applying this fiction under the mutual agreement, no change of the payroll setup is in principle required by the employer. If we look, for example, at a German resident who lives in Germany and who usually performs his working activities at the Dutch employer, the Dutch company can, by applying the fiction, tax 100% of the income via the Dutch payroll as it was done before the COVID-19 situation. However, please note that it's not obligatory to the monthly payroll. The employee can actually choose if the mutual agreement should be applied or not. In case the fiction is not yet applied to the monthly payroll, the fiction can also be applied within the annual income tax return for 2020 of the employee. In case the employee chooses that the fiction should not be applied to the actual travel pattern, it has to be taken into consideration for the allocation, and now it has to be applied for Article 14 accordingly. The fiction cannot be applied to days where the cross-border employee would have normally been working from home or in a third country. In order to apply the fiction, it has to be made sure that both Germany and the Netherlands as contracting states consistently apply the fiction at that the incomes and the working state, so that the individuals can benefit from this fiction. In practice, it should be very handy to apply the fiction to employees that are working on a local employment contract in either Germany or the Netherlands and living in the other state, or that are working in one of the two countries based on an assignment contract with a fixed usual working pattern. When looking at commuter assignments, it might be more difficult to deal with this kind of cross-border employment in order to determine a fixed working pattern. Most of you probably also face this in practice, that commuters do not have a travel pattern that's regular. Therefore, it should be paid attention to this assignment population before the mutual agreement will be applied. In order to prevent employees from unemployment during the current crisis, Dutch employers can, of course, under certain conditions, continue to pay the employee's salary for 100% work performance while receiving 90% of the wages back from the Dutch government. This is the so-called Now ruling. Based on the Now ruling, employees might continue to receive employment income from their employer while spending some of their days without working at home. So the agreement between Germany and the Netherlands has also included a section to deal with this. The mutual agreement clarifies under number 3 that if an employee stays at home for one or more working days without working, but if he continues to receive employment income, the income will be taxed according to the same working pattern as if the employee without the COVID-19 measures. In contrast to the fiction that was discussed on the previous slide, the application of this fiction is obligatory. So this means that the employee cannot choose if he would like to apply the fiction to a specific tax situation or not. Therefore, a change of the payroll setup is not required in this case. But let's have a look at the impact of the fiction that it will have at our employee who is a German tax resident and who generally works for a Dutch employer but who cannot travel to the Netherlands based on the travel restrictions. The days the employee spends at home in Germany without working but while receiving salary from the Dutch employer have to be considered as working days being performed in the Netherlands, as the employee would have exercised his work in the Netherlands without the COVID-19 measures. As a result, the income referring to these days is subject to taxation in the Netherlands and should be exempted from taxation in Germany. Under number 4 of the mutual agreement, the agreement includes a section how social security benefits that are paid out from a German employer should be treated in the Netherlands for double tax treaty purposes, provided that the employee receives these payments while staying at home in the Netherlands without working. The mutual agreement refers to the following social security payments in specific: German short-term allowances, in German it's Kurzarbeitergeld, unemployment benefits, in German it's Arbeitslosengeld, or bankruptcy money, in German it's Insolvenzgeld. Due to the agreement, the allowances are considered as net income in the Netherlands. In Germany, they are also considered as net benefits. So in case the social security amount in total less than 50,000 euros per year, Article 17 of the double tax treaty between Germany and the Netherlands should be applied, meaning that the payments should become taxable in the state of treaty residence, in this case in the Netherlands. When looking at the employee who is a Dutch tax resident working for a German employer, not being able to work in Germany during the corona crisis and receiving, for example, short-term allowances for 5 months in the amount of 10,000 euros, the payments generally become taxable in the Netherlands as state of treaty residence. However, the Dutch tax authorities grant a tax relief for these payments. Due to a decree, the payments are exempted from taxation in the Netherlands but considered for progression purposes. This applies to all benefits received until the end of this year, so until the end of December. For completeness sake, the above-mentioned social security payments are also not considered as taxable income in Germany due to national German income tax law. However, they also must be considered for progression purposes in Germany within the annual German income tax return, of course only in case the employee has the obligation to file a German tax return. To sum it up, the intention of the agreement is to provide clearness on the income tax situation of individuals working in one country while residing in another country and that are now forced to work from home during the COVID-19 pandemic. Careful consideration should be given to the situation of individuals working in more than one country or individuals that are regularly working from home or in third countries, also prior to the COVID-19 period. My colleague Fanny will now cover the social security aspect in this context.
Yeah, as Sabrina already mentioned, that mutual agreement between Germany and the Netherlands only refers to the tax situation of employees. It does not include any social security issues that might arise by COVID-19. From a social security perspective, the European Commission encouraged that during this COVID-19 period, countries are putting in place arrangements and guidance for social security for the benefits of mobile workers. Officially, the normal European rules on the coordination of social security continue to apply. However, these rules offer a certain flexibility, and the European Commission advised the following in that respect. They advised if someone is insured in his working country and needs to work at home during COVID-19, this should not lead to a change of the social security system. The situation is only temporary. They gave examples for a multi-state worker. They say who is insured in the working state because he normally does not work more than 25% in his home country. He could been working more than 25% in his home country due to COVID-19 during that short period. European Commission said we do not see any issues there, as the 25% needs to be determined in a 12 months period. However, at the moment they mentioned this, they had an idea that this COVID period would only last for about 5 weeks. We see it will be much longer. For multi-state workers who already are insured in their home country because they already work more than 25% there, obviously COVID-19 will not impact the Social Security position because they will only work more days from home. Well, the only thing that we have is an opinion of the European Commission, but this is just an opinion. It's up to the member states how to deal with the Social Security position. It's not like a binding ruling. Well, let's see what Germany and the Netherlands did. The German authorities mentioned that COVID-19 situation does not impact the Social Security position of local hires and multi-state workers in case these employees cannot work in the work country due to COVID-19. What they also mentioned that it's not required to adjust the A1 certificate or to issue, to apply for new A1 certificates. The same goes for posted workers, for the SMEs. However, note that for these employees, the end date of the Social Security period remains the same. So it cannot be extended with the period that the employee was not assigned due to COVID-19. So in case there will be an extension of the assignment, a new A1 needs to be applied for in that case. What does the Netherlands say? The Dutch tax authorities basically said the same. However, they used other wordings. They said by posting that working from home due to COVID-19 will not affect the Social Security position of the employee. However, this is only applicable within the Europe, the European Economic Area and Switzerland. However, where Germany explicitly mentioned the situation on the SMEs, the Dutch authorities did not. They did not yet issue any guidance for this so far. Furthermore, the Dutch authorities mentioned that someone who starts a new job in a new member state will be insured in that member state even though he will start his job from home. To give you an example, a German resident who would start a new job in the Netherlands on June 1st, he would move to the Netherlands, he would in the Netherlands, but due to COVID-19, he will still start his job, but he will do that at home in Germany. And he will only move to the Netherlands as of August 1st, 2020. Well, according to the Dutch authorities, he will still become socially insured in the Netherlands as of June 1st, 2020, even though he's still fully in Germany working and living. Well, to sum up, for the cross-border workers between the Netherlands and Germany who continued working during COVID-19, although from home instead of their normal working place, the tax and social security situation should not have changed. This is because of that mutual agreement between the Netherlands and Germany with respect to the taxation, as well as both points of view of Germany and the Netherlands regarding social security. Employees have a choice what working days to apply in the tax days they continue to work, so the active employees, they can choose the what-if working days or they can choose the actual working days. They can check what's most beneficial, but note that it needs to be done, it needs to be the same in both countries. So the advice for these employees is to administer both working scenarios. So far, Germany and Netherlands. I now want to do a sidestep to other international employees and COVID-19. For example, do the Netherlands and Germany have other mutual agreements? And what are the OECD recommendations? And what about social security in an international perspective? To start with the first question, do the Netherlands and Germany have other mutual agreements? Well, the answer is yes. Germany was very fast in concluding mutual agreements with several countries. And meanwhile, they have agreements with the Netherlands, Belgium, Luxembourg, France, Switzerland and Austria. All agreements are basically the same as the agreement that the Netherlands concluded with Germany. Germany concluded with the Netherlands. Only there are some small deviations, and that's due to the difference in the tax treaty itself. So there needed to be some other rules. The Netherlands has only concluded a mutual agreement with Belgium, which is also basically the same as the agreement with Germany. What if there's no mutual agreement and COVID-19 would impact the tax situation of an employee? Well, note that most tax treaties are based on the OECD Model Tax Convention. That's a model presented by the Organization for Economic Cooperation and Development. The OECD also provides guidelines for the interpretation of various articles in that OECD and in the tax treaties. For the COVID-19 situations, the OECD provided recommendations on how to deal with COVID-19. However, it's important to be aware that these are only recommendations. These are not binding rules. Countries need to take action to implement this. For example, what the Germany and Netherlands did with that mutual agreement. Without that mutual agreement, in principle, the main rules of a tax treaty apply. For example, if a German or a Dutch resident would formally commute to the UK and is now working from home, nothing is officially taken care between the UK and Germany or the UK and the Netherlands to mitigate these unplanned tax consequences. This would mean taxation, a switch of taxation to the home country. And that is exactly the recommendation of the OECD. Countries need to mitigate unplanned tax consequences due to COVID-19. They say these exceptional circumstances call for an exceptional level of coordination between the countries. What does OECD exactly recommend? From an income tax perspective, they have two recommendations. The first is related to cross-border workers, being employees, so not the directors. And the second one is related to the residency position of employees. To start with the cross-border workers, according to the OECD, in case a government has stepped in to subsidize the keeping of employees on the company's payroll, for example, that now ruling that we have in the Netherlands, the income should be allocated to the state where the employment used to be exercised. The OECD is of the opinion that such payments most closely resemble termination payments for employees. And therefore, they say the allocation recommendation is in line with the allocation of termination payment. But more widely, so not only in case the government steps in to subsidize the salary payments, also in a more broader perspective, OECD recommends to mitigate the compliance and administrative costs for employees and employers due to the involuntary and temporary change of the place of work during COVID-19. But again, it's up to the countries what to do with it. Going to the residency position of an individual, this is very clear according to the OECD. It's very unlikely that the residency position of an individual will change due to COVID-19, due to the fact that this is only a very temporary dislocation. And the residency position is mostly determined based on a situation that lasts for a while. There are countries that have local rules to determine the residency based on a number of days that are spent in the country, for example, the UK. COVID-19 the residency position of that individual in that country. However, OECD mentions that this would not affect the treaty residency position, as this is based on facts and circumstances and not on counting days. What about Social Security worldwide? Well, there is no worldwide guidance, only the opinion of the European Commission that I already discussed. Most European member states confirmed that they will act in line with this guidance, but it's important to check for both or all countries that are involved what their point of view is. You saw that the guidance in the Netherlands and Germany also slightly differ from each other, and this can also be the case in other EU countries. But what if an employee works outside the EU in a state with which a social security treaty is concluded? As mentioned before, did not issue any guidance so far on these countries. Germany did basically by saying in more general that COVID-19 could not impact the social security position of local hires, multi-state workers and posted workers. They did not mention that only for EU workers. So also in these cases, it's important to check what is the point of view of the other country. In these situations, we do not see a lot of cross-border workers. Mostly it's local hires and posted workers because those countries are further away. Posted workers often remain socially insured in the home country under such social security treaties. And this will not change in case they will work at home during COVID-19 because they already were socially insured in the home country. Well, what if the employee works outside the EU and in a state with which there's no social security? Well, then the employee is at the mercy of each country's own rules and guidance. So also there, check the rules of the local country. And that's really the takeaway here for social security, because there's no guidance, worldwide guidance. Please check for all countries involved what are the consequences in that country for social security. So far, the international employees and COVID-19, the OECD did not only provide recommendations on an income tax level, but also on a corporate tax level. Hannes will guide you through these recommendations in the next part.
Thank you, Fanny. So from a corporate tax perspective, two main areas have to be considered that may be impacted where employees of a the status of tax residents of relevant companies, and second, whether permanent establishments may arise due to employees being dislocated to another country. In this respect, I will first cover the general rules, the German interpretation, and also OECD recommendations. Martine will then add some thoughts from a Dutch tax perspective. The residence status of a company determines whether it's unlimited liable for tax. It also gives rise to comprehensive registration and compliance obligations, and therefore has to be carefully considered. As corporate tax implications are not covered by the mutual agreement between the Netherlands and Germany described before, the general rules apply. Under Dutch and country where either its statutory seat is located, that is typically the country of incorporation, or at the effective place of management. While the statutory seat should not be affected by COVID-19, the effective place of management may well be where directors of, for example, a Dutch company work from their home in Germany during COVID-19. This may result in a dual residency of the company in a first step. The tiebreaker rule of the Dutch-German tax treaty in this case determines the effective place of management to be decisive over the statutory seat. Thus, it needs to be assessed if the effective place of management is impacted by the temporary relocation of directors. Neither German nor Dutch tax authorities have issued guidance on this question to date. However, the OECD guidance of 3rd April, already mentioned by Fanny, sets out the following in this respect. The OECD believes that COVID-19 is unlikely to create any changes to a company's residence status under a tax treaty. The focus of the OECD in this regard is very much on the fact that the temporary change in the location of directors due to COVID-19 is an extraordinary and temporary situation. According to the commentary on Article 4 of the 2014 OECD model, the place of effective management is the place where key management and commercial decisions that are necessary for the conduct of a company's business as a whole are made in substance. And on this basis, in the OECD's view, all relevant facts and circumstances should be examined to determine the usual and ordinary place of effective management, and not only those items that pertain to an exceptional and temporary period, such as the current COVID-19 crisis. First countries have already adopted the OECD interpretation. As Fanny mentioned before, these rules are not binding but need to be implemented nationally to be effective. So for instance, Ireland's revenue has issued guidance to disregard the presence of companies' directors in a country other than their usual place of work if such presence is shown to result from travel restrictions related to COVID-19. And as just mentioned, as the OECD interpretation is not binding and the Netherlands and also not Germany have yet issued similar guidance than the one just described for Ireland, documentation on the reasons for the temporary dislocation of directors, for example, travel restrictions or government directives, should be prepared. Second, were legally and or factually possible, it could be considered to postpone board meetings and similar meetings. Third, decision-making could be temporarily delegated, in particular in a situation where a company has several directors in different home locations. And likely the most important recommendation, it should be carefully monitored how the situation and travel patterns develop over time. Employees, including directors of a company, got used to working remotely very quickly during COVID-19. Current situation where restrictions are starting to be lifted in many countries, and this may quickly result in a situation where it could become difficult to demonstrate that the dislocation, the continuous dislocation, is still temporary and still COVID-19 indicated. Particular attention to this should be given at companies that require rather limited management activities, such as, for example, holding companies, where tax authorities may challenge if relevant substance requirements in the respective country are still met. The second area to be considered is permanent establishments. A permanent establishment is defined as a fixed place of business through which the business of an enterprise is wholly or partly carried on. Under this, the place must be one of business. That basically means it must be at the disposal of the business, not at the disposal of the employee. In Germany, a home office generally should not be considered to be a fixed place of business under domestic law, because typically it is not at the disposal of the business. However, other countries, for example, Austria, take a much stricter approach in that regard. Therefore, this should be checked on a country-by-country basis. As for questions around tax residence, to date, there is no COVID-19 specific guidance by the Dutch or German tax authorities available. OECD recommendations on COVID-19 set out the following. Generally, a permanent establishment must have a certain degree of permanency and must be at the disposal of an enterprise in all place to be considered a fixed place of business. While according to the OECD model commentary, this is already typically not the case under normal circumstances, during COVID-19, the extraordinary nature of the situation shall be taken into account in addition. Therefore, to the extent it does not become the new norm, working remotely from home should not give rise to a permanent establishment of the business, either because it lacks a sufficient degree of permanency or continuity, or because the enterprise has no access or control over the home office of the employee. This is further supported where relevant employees have an actual physical office at the location of the employer, and access is only temporarily restricted due to COVID-19. OECD guidance also touches on the question of agency PEs and broadly provides similar answers. Generally, the activity of a dependent agent, such as an employee, will create a permanent establishment for an enterprise if the employee habitually concludes contracts on behalf of the enterprise. In the OECD's view, it is unlikely that the activities of a dependent agent should be regarded as being performed in a habitual way if he or she is only working from home for a short period because of force majeure or government directive extraordinarily impacting the normal course of business. The situation may be different, however, if that employee was already habitually concluding contracts on behalf of the enterprise in his or her home country and independently of the COVID-19 crisis. Finally, and for the sake of completeness, the OECD also gives guidance on construction site PEs, which is less a cross-border topic in the sense we've discussed during this webcast. Under the tax treaty between the Netherlands and Germany, a construction site gives rise to a permanent establishment if it exceeds the duration of 12 months. And according to the OECD, COVID-19 disruptions should be included in determining the life of such site and thus will affect the determination whether a construction site constitutes a permanent establishment. That is, there is no break in counting the 12-month period relevant for a permanent establishment if such break occurs, in particular due to COVID-19. In absence of domestic guidance, in order to mitigate the risk that in particular the home office of an employee may be considered a permanent establishment of the employer, recommendations are similar to those already given on tax residence. First, maintain careful documentation on the background of temporary dislocation of employees and dependent agents. And second, carefully monitor how the overall situation and travel patterns develop over time. Because without any doubt, COVID-19 has changed the way we all work together and has accelerated digitalization, including remote working models. The effects are unlikely to fully disappear once hopefully COVID-19 disappears and will continue to impact the questions we have just discussed. And over to Martin.
Yes, thank you, Hannes. For a lot of Dutch entities, the place where decisions are taken is particularly important, not just in view of the residence and permanent establishment risk, but also because of the substance requirements for financial service companies and the risk of an automatic exchange of information if the substance requirements are not maintained. The Dutch Order of Tax Advisors has repeatedly asked the Dutch tax authorities and the Ministry of Finance to come with measures to apply a lenient approach in these times, where it is, of course, very difficult to have physical board meetings in the Netherlands, especially for non-Dutch board members. But the Dutch authorities have been reluctant to take any measures and have said in informal meetings with us that this topic is not high on their list of priorities. So unfortunately, we still have to work with the students. I hand over to Fanny for the final topic. Fanny, you're still on mute.
Oh, sorry. Before closing, there are 3 things I wanted to inform you about. The first one is the Dutch BSN application. BSN is the Dutch Tax and Social Security number which an employee needs to apply for at the tax authorities when starting to work in the Netherlands. Normally, the only way to get a BSN is personally, via an appointment with the tax authorities. This is not always possible during COVID-19, also due to travel restrictions. Therefore, during this period, it is possible to apply for the BSN in writing. In case this is applicable to one of your these, we are happy to provide you with some more guidance on how to do this written application. Second one is the fixed travel allowance of 19 cents per kilometers. Question can of course be whether this is still allowed now that the employees are working from home during COVID-19 and are not traveling. Well, the answer is yes, it is. All fixed allowances can be continued, assuming that the normal working conditions would still be applicable without COVID-19. In case after COVID-19 these working conditions will change, the allowance of course needs to be reconsidered. What Hannes already said, you hear companies considering the new working after COVID-19, which is maybe more home working. That would of course affect also the travel allowance for the future. Then the last one, I want to make you aware of the COVID-19 tracker that we have and that you can access via the link in the slide after this presentation. The COVID-19 tracker shows worldwide information per country regarding travel restrictions, government measures, as well as tax, payroll and immigration information during COVID-19. It's being updated at about every 2 to 4 days, and it's very helpful information in case your business acts worldwide and you want to know whether travel is possible again to a certain period. You see the world map and you can click on the country and been guided directly to that country to see all the information. So having said that, I would like to hand it over to you, Martine.
Yes, thank you very much, Fanny. We have seen a few questions in the chat that we may take up because we still have a couple of minutes left. Is there any question that we can take up right now?
Yeah, I just have one question of Ellen, and I also mentioned indeed we will come back to it at the end of the webcast or after. She was wondering, she understands that the warning that lifting of restrictions can lead to discussions on whether place of business has only changed due to COVID. And she mentioned, is this not the same for employees working from home? What if borders are open but business only opens slowly? For example, employees get only access for 2 days a week. Can someone of you comment on that?
Yeah, well, I think this question was raised during the corporate income tax session of this webinar, so I'll take it up for corporate income tax purposes. Well, what we see is that the OECD only provided this guidance to member states, saying that be flexible and lenient and not take the COVID-19 absence into account. This will of course be taken into account by member states, but we don't have any actual guidance yet. And we also don't know how it will go going forward, because this new normal of people working from home will of course have a risk for residency and permanent establishments and substance. So it's quite uncertain how it will go forward in the particular member states.
Yeah, and Ellen mentioned also it came up during the corporate tax indeed, but she was also wondering on the impact on personal tax. So maybe Fanny can also comment on that.
Yeah, so a bit the same as Martine says, and what you also said, mutual agreement between Germany and the Netherlands is extended every time with 1 month, but probably when the governmental measures are, let's say, all gone and everything is open, the question is what will companies do themselves and remain working at home, and then probably the mutual agreement will stop at one point, and then the situation is back to normal, and then it can still change the tax situation of employees.
Yeah.
Thanks, and also Nick had a side question to that he was wondering it as well, and was wondering how lenient the tax authorities are on the burden of proof on this.
Yeah, well, not sure yet. So that's exactly what we've been asking from the Order of Tax Advisors and KPMG also in separate settings with tax authorities. Please confirm that there will be some lenience even able to do so.
Yeah, and from an income perspective, it's maybe more easy. It's just having a correct travel diary. And Sabrina was talking about, of course, commuters who, in a normal situation, maybe do also not have a regular pattern. I think it would be, but that's my opinion, that you can check what was the regular travel pattern in the last year or in the last 2 years. If there is like a pattern in based on a year, maybe you can use that for the what if scenario. But keeping a track of your days is very important in both situations.
Thanks. Let's see. Ellen also mentioned whether we have an idea about the timing, but I guess we don't, right?
You mean if she means the timing of the mutual agreement, when this will maybe stop? No, we haven't. I have seen that explicitly it was mentioned that the mutual agreement between Belgium and the Netherlands was extended until the end of August. But in principle, there's no need to extend it because it will be extended automatically with 1 month. But it's not yet sure when it will stop.
Yeah, and Sjoerd mentioned where we can share the link of the COVID tracker. We will. Sjoerd, we will share it.
Okay,
I guess these were all the questions we had unanswered.
Okay, thanks, Rachel, for keeping track.
You're welcome.
Then I think it's time. Our webinar, we've heard from the experts. There was some quick action taken by the German tax authorities to formalize bilateral agreements with their neighboring countries and with the Netherlands as well, solving quite a few practical questions in these time of travel restrictions. On the other hand, we hear that uncertainties still remain, for instance, on corporate income tax topics such as residence and substance, and also going forward in this new normal of working from home more frequently. Thanks to everybody who contributed to the presentation and the Q&A. Slides will be distributed after the presentations. And if you have any questions, please reach out to us. And bis zum nächsten Mal. See you next time. And tot ziens.